never slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast, I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior.
Would counsel please put their appearances on the record?
Your Honor, Christine Lento for the state.
Assistant Prosecutor Jamie Schroen for the state.
Good morning, Ms. Lento. Good morning, Ms. Schroen. Good morning, Your Honor. Good morning, Ms. Ferrante. Mario Gallucci on behalf of Mr. Gregor, who is seated to my left.
Thank you.
Andrea Ferrante. Good morning, Your Honor.
Thank you. Good morning, everyone. Mr. Gregor appears in court appropriately attired in a suit and tie. Counsel asked to conference in chambers this morning, so I apologize for the late start. We continue to experience a variety of challenging witness issues in terms of scheduling, which is unfortunate, but the only way to address it is to deal with them the best we can. So at this point, I know we wanted to have some discussion about some further witnesses, but Mr. Gallucci, do you want to proceed with your one witness today?
Yes, I'm going to proceed with Mr. Gregor.
All right. Any objection to that process?
No, Your Honor.
All right. So we can go get the jury, and then we'll bring them over, give them a few minutes to get settled.
Judge, did you want to, I don't know if counsel wanted to put some things on the record now or after.
Up to you.
About the other witness?
Yeah.
I thought we said we'd wait till after this witness.
Oh,
The jury's already
very
been
well.
here almost an hour, so I'd
Thank
rather
you.
get the jury over
That's
here.
fine. Thank you, Judge.
Thank you.
change the launch pad one day.
All right, it's 10:03 a.m. Jersey and jury room. Give them a minute to get settled. Advising that there is a revised schedule that the one defense witness that's necessary, that's unavailable, is going to be available on Friday the 24th, not Thursday the 23rd. So we had not given them that date before. I likely told them they wouldn't be coming in that day, so I think we should tell them as early as possible, but that's a change of plan. Any objection to me saying that before we start?
I think that's best.
No objection.
All right. You're not doing that.
We did.
Okay. Thank you. Seated, everyone. Good morning, ladies and gentlemen. Thank you for your patience today. Any concerns or issues you want to bring to my attention at all? All right, so a couple things to tell you. First is that there's a major construction project about to start here. So you can see on the north side of the parking garage, the area has been fenced off for, I guess, a staging area for construction equipment. And then the construction is going to start immediately on the north side of this building, which is previously been a parking lot. So I understand one or more of you may have been parking there, and that's going to close effective tomorrow. So that means the only place to park is across the street in the parking garage. If you have a handicap sticker, I think you can park in a meter space, and that usually prevents Tom's River Township from issuing any meter summonses to you if you have handicap placard. Is that right, Sergeant?
I don't know, she's tough.
I know she's tough. You have to look into that. I believe that's the case. So I apologize for that. I'm hoping that this trial's over before we run into a lot of construction noise. It's my problem for future cases, but hopefully it won't be our problem together in this current case. But they're at least going to start doing some work, prep work, at that lot this week, I believe. Next issue is scheduling. We do have some things for you today, but it probably won't be the whole day. The plan is for some witnesses tomorrow, again, not Friday. And then next week, we're still having some challenging scheduling issues. So right now, I'd say be prepared for Tuesday the 21st, which I previously told you. Definitely Wednesday the 22nd, but now one of the witnesses that was scheduled on the 23rd is testifying in another state, so he's not going to be available until Friday the 24th. So I originally told you not Friday the 24th, so it looks like definitely the Friday the 24th will have to be here, but likely not Thursday the 23rd. So I apologize for that. If that presents an issue for anybody, let us know, and we'll have to address it. But if you can't be available on Friday, That's the Friday before the long weekend, before Memorial Day weekend, and then that Monday, of course, is the Memorial Day holiday. So if you need to think about that for a little bit or whatever, let us know before the end of the day if there's anything to discuss about scheduling, but that will be the plan going forward. Anything else from council before we go for next witness?
No, Your Honor.
No, Judge,
All right.
thank you.
All right, so Mr. Gallucci, remember the state has not rested, but Mr. Gallucci's calling some witnesses out of order, so that's going to happen today. Mr. Gallucci.
Thank you, Your Honor. We call David Gregor.
Hi, sir, come on up. Raise your right hand so the court reporter will swear you in.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. State your name and spell your last name, please.
David Gregor, Gregor.
Thank you, Mr. Gallucci.
Thank you, Your Honor. Good morning, Mr. Gregor.
Morning.
Mr. Gregor, how old are you?
64.
Are you currently employed?
I'm self-employed, yes.
Okay. And what did you do before you were self-employed?
My career, I spent 27 years as a state trooper.
Okay. And was that in New Jersey?
It was.
Okay. And what roles did you have when you were a state trooper?
Various roles. I started off in as a road trooper, went to a tactical unit for half dozen years, emergency management, and then later in my career, Homeland Security.
Okay. And did you, when you were a state trooper, did you teach at all?
I did.
Okay. What did you teach?
Many disciplines. I taught initially in special operations. I taught scuba diving. I was a firearms instructor, self-defense instructor. Later in my career, emergency management, crisis management, consequence management, a whole host of disciplines.
Okay. Now you said that currently you're self-employed. What are you self-employed at?
I do. I do various consulting with regards to Homeland Security strategic planning, continuity of operations planning, emergency management exercises, traffic management.
Okay. Are you married?
I am.
And what's your wife's name?
Carolyn.
Okay. And do you have any children?
I do.
And what are their names?
David, Kimberly, Christopher, and Daniel.
Okay. And do you have any grandchildren?
I have one.
Okay. When your children were young, were you involved in any of their activities?
I was involved with all their activities. Sports, certainly the school, brownies for my daughter, ballet, just about everything my schedule would allow I was involved with.
Okay. And were you aware of your children's activities as far as high school and college and where they were?
Very much so.
Okay. Were you aware of Christopher's college education?
Yes,
Okay. Did there come a time when Christopher moved to Baltimore?
he did.
Okay, and when was that?
2017.
And do you know why he moved to Baltimore?
I do.
Okay, and why was that?
Christopher was entering Johns Hopkins program, which was called the Urban Teachers, for teaching in the inner city. And at the time he was going to school, he was earning his master's while he was under a mentorship with other teachers in Baltimore.
Okay. Now, prior to Christopher moving to Baltimore, did you know a person named Rebecca or Brianna Michola?
No.
Okay. When was the first time you knew of their existence?
I received a phone call the end of 2017, beginning of 2018, from a lady that identified herself as Rebecca.
Now, where were you living at the time you received that phone call from this person?
Monroe, New Jersey.
Without telling us what Rebecca said to you, or this person that said was Rebecca, without telling us what she told you, what, if anything, did you do as a result of that?
As a result of that phone call, I called Chris.
Okay. And after you called Chris, did you receive another phone call from this person?
Yes, I did.
And when was that?
A few weeks later.
Okay. And after you received that, without telling us what that person told you, what, if anything, did you, as a family, make a decision to do?
It wasn't until after the second phone call that a third phone call came from Rebecca to discuss how we were going to get involved.
Okay. Is that when you became aware that you actually had a grandchild?
It was.
Okay. And did you learn the name of that grandchild?
I did.
Okay, and what was the child's name?
His name was Corey.
Okay, and was that your first grandchild?
It was.
And do you know how old Corey was when you first became aware of him?
Yes. He was about 4 years old.
Now, when you received that phone call, did you come up with a plan?
We did.
What was that plan?
Well, Corey began visits with us. And so our plan was to make him as comfortable as possible when he came to the house, which involved, it was almost as if you were bringing home a newborn. It was finding out his favorite foods. It was what size clothes he wore. It was getting out all the old sports equipment that I had put away years ago for my kids. It was creating an atmosphere for him to make him comfortable. We redid the bedroom next to ours, which had been my wife's office. It was originally a bedroom. And then as our children moved out, it became an office. It was a bedroom again. So we bought a toddler bed and bought a mattress and put a school desk in the bedroom. It was all encompassing.
Do you recall the first day when you met Corey?
I do.
What day was that?
August 8th.
Okay. Now, at that time, did your family have visitation with him?
Not yet. That visit was set up, and Christopher went to pick him up and brought him to our house for a couple hours.
Okay. Did visitation ever change where it became more than just that couple of hours?
On August 28th is when he had come to the house for an extended visit. And it was a Saturday and a Sunday, if I'm remembering correctly. And then subsequent to that, in October, is when Christopher got a shared custody agreement.
Okay. Now, you said a shared custody agreement, and when was that?
October, I forget. It was in the very beginning.
Okay. Now, and that was in 2019?
19.
Okay. So in October of 2019, did Christopher become the residential parent?
He did.
Okay. And when he became the residential parent, where was Christopher living?
With us.
Okay. And from October of 2019 until at some point Christopher moved?
He did.
And when was that?
August 28th of 2020, he moved to Barnegat.
Okay. So from October of 2019 to August 20th of 2020, where did Corey live?
In the beginning of October through January, he was back and forth between locations. January 28th is when he was actually full-time with us in terms of being the residential parent, if you will.
Okay. Now, from the day, who lived with Corey when he lived in your home?
Well, my wife, myself, and Christopher, then my daughter Kimberly, and my other son Daniel.
Briefly explain the daily life of what happened when Corey was home with you living.
So he came to us full-time at the end of January, and school was in session. So at the time, Christopher was teaching in Camden, and it involved early departure and a late arrival at home. So in essence, for the first few months, I felt as if I was the dad. And so the day would begin when he got up, and we would help him get ready for school, take a shower. My wife would make him breakfast. My wife was working at the time. Being self-employed, I had somewhat flexible hours. I tried to make it around Corey's schedule. And so it was all-encompassing. It's going through his book bag, making sure his assignments were in there, whatever permission slips or money he might have needed for that day. It was seeing him off to school, waiting for him to come off the bus at 3 o'clock. They dropped him off right in front of the house, and generally I was there waiting with some kind of sports item or And he would come back and we would be engaged in some kind of activity so he could unwind. And then I'd bring him in, and the first thing is we went through his book bag. And I say, wait, it was me, because generally it was in the 4 o'clock or so area. My wife was just getting home. And we had an agreement with the school at the time, as part of the program he was in, was to give us an analysis of how he did in school that day. And so every day there was teacher's notes in a little blue book he used to keep, and it was the first thing I went through when I went through his book bag, see if he had a good day or did he have a bad day. And then subsequent to that, it was homework, dinner. Hopefully Chris was home by that time so he could eat with him. If he wasn't, we did that. We got the homework ready, and it was always something that Chris wanted to spend the end of the day with, him doing his homework.
Now, where did Corey go to school when he moved in with you?
At first, he was in Jamesburg School.
Okay, and did that change?
It did.
And where did it change to?
Right in the beginning of October, when the residential custody was assumed, we had meetings, Chris and I had meetings in Monroe to move him to the Barclay Brook School.
Okay, and that's located in Monroe.
It is.
Okay. Now, there comes a time when Christopher and Corey move out of your Monroe home, right?
Yes.
Okay, and when was that?
August 28th, 2020.
And where did they move to?
Barney?
Okay. So, in 2020, Christopher moves down to Barnegat, and who lived with Christopher?
Christopher and Corey.
Okay, so they lived together.
They did.
Between the time that Christopher moved to Barnegat and March 20th, did you see Christopher and Corey?
March 20th, 2000.
21.
I'm sorry, I was focused on something else.
Okay. When Christopher and Corey moved out,
Right,
on that day,
from August.
from August
To March.
March 20th of 2021, did you ever see
Oh.
Christopher and Corey?
Yes, many times.
Okay. How often?
As often as we could get down. We would take, I used to crab a lot in that area, so I would go down during the week if my schedule permitted, and the priority wasn't crabbing, it was getting over to the house and usually dropping off some kind of care package and spending some time with him if he wasn't in school at the time. And on the weekends, my wife would encourage me to go. I don't know how many times, many times.
We've seen a video of a treadmill incident that occurred on March 20th of 2021. Have you seen that video?
No,
Why not?
because I don't want to see Corey mistreated.
Okay. Between March 20th and April 2nd, did you see Corey?
I did,
And when was that?
March 22nd.
Okay. And why did you see Corey on March 22nd?
On the 22nd, Chris and Corey, they were looking for a home to purchase. And so, being that we were involved with the purchase in terms of helping, we went down, my wife was a real estate agent, and showed them 2 houses in Bayville. Was one, the other one was near Barnegat.
Okay. And how many houses? Did you look at 2 houses?
2 houses.
Okay. And did you see Corey that day?
We did.
Okay. And what was Corey's demeanor on March 22nd?
He was happy and energetic. We were, the entire time we looked at both homes, we were talking about where his room would be and where would it be his yard to play with the dog. He was excited. He ran around a lot. I remember that because there was a situation at the one house on a trafficked street where as we were walking in the house, he ran out of the car and was running through the front yard, and my wife got all excited and ran after to get him because she was concerned with the street. But he had a lot of energy. He was very excited.
Okay. Now, after you looked at the houses, what, if anything, did you do next?
We visited my brother-in-law down in Barnegat.
Okay. And was Corey there?
He was.
And how was his demeanor at your brother-in-law's house?
Same. Happy, energetic. We were talking to him. I'm sure the visit was boring, but we kept saying, hey, we're going to go out and eat, and you're going to get French fries and everything to further his attention because it was all the adults visiting with each other.
By the way, what was Christopher's demeanor on the 22nd when you were looking at the houses?
concerned. It was a major step in his life to purchase a home. Concerned that he could afford it. The homes we were looking at, of course, were all fixer-uppers. You know, we were helping. He's just starting off in his line of work, so funds were limited. And
Objection, Judge.
I really go with it.
Okay.
Just saying.
So, what was his demeanor, was the question I asked.
he was concentrating on the home, so he's very concerned.
So when you got to your brother-in-law's house, what was Christopher's demeanor?
Relatively happy, you know, asking questions about how could we do things with the homes. I'm talking about a whole host of things, but, you know, it seemed relatively normal to me, other than the excitement about what the homes brought.
Okay.
Objection, Judge. It's speculation as to his subjective opinion as to normal.
They asked the answer, so it's fine.
Thank you, Judge.
After you visited with your family, did you finally take Corey out to dinner?
We did.
Okay. And where did you go to dinner?
We went to the Sun Harbor Grill in Barnegat.
And what was Corey's demeanor at the Sun Harbor Grill?
He's excited, excited about the food, and we talked about a whole host of things, but he was happy.
Now, between March 22nd and April 2nd, did you see Corey?
No,
On April 2nd, did you hear from Christopher?
I did.
And about what time did you hear from Christopher?
It was sometime after 5
Okay. And where were you at the time?
in the car.
Okay, and where were you going?
My wife had called me. I went home to pick her up, and we were heading down to Barnegat.
Okay. And can you please describe the conversation you had with Christopher, that first conversation?
The first conversation is when I took the phone from my wife. Christopher was on the phone with her. I could hear it was loud and very excitable, and I asked her to give me the phone, and then I got the phone.
Okay. What was Christopher's demeanor during that conversation?
Hysterical.
When's the next time you heard from Christopher?
A few minutes later.
Okay. And describe that conversation.
It was the same. He was inconsolable. He just lost his son.
When's the next time you heard from Christopher after that? Did you call him or he call you?
I think there was a call right before 5:30, a relatively short call. I forget if he generated or I did.
And after that, when's the next time you heard from your son?
The next day, sometime afternoon, I think it was after 1 actually.
Okay, so that would be April 3rd.
It would be.
Okay. And what, if anything, did you discuss with your son?
I discussed one, where was he? And then I discussed, you got to be back here. We were distraught. Told him to come home.
Okay. And did there come a time that you rented a car for him?
I did.
Okay. And why did you rent a car, if you know?
I do. He was stopped in Tennessee, and he had to give up his vehicle and his cell phone, and he was without transportation.
Okay. So did you arrange for transportation for your son to come home to New Jersey?
We made several calls and located a rental car place, and that we had made a call. I don't know who paid for it, but we were involved in trying to secure a vehicle for him.
Okay. And he eventually returned to New Jersey?
He did,
And what day was that?
April 5th.
Okay, so 3 days later. Okay,
Yes.
And when he arrived home in New Jersey on April 5th, where did he live?
With us.
After April 5th of 2021 until July, where did Christopher live?
With us.
And in July, did there come a time when police came to your house?
Yes.
And do you recall what day that was?
July 8th.
Okay. And which police came to your house?
Barnegat someone from the prosecutor's office and from my town, Monroe.
Okay. And what, if anything, did they ask?
They were looking,
Objection, it's hearsay, Judge.
What, if anything, did they do?
Right, that's fine.
well, they were looking for Christopher. They had asked me where he was.
Okay, and was he home?
He wasn't.
Okay. Do you know where he was?
I do.
Where was he?
He was on a hiking retreat out in western Pennsylvania.
Okay, and how did he get there?
My wife dropped him off.
Now, did you talk to him on July 8th?
I did.
Okay, and what did you tell him?
Exactly what I just said. The police were there and they were looking for him. They shared with me that there was a charge against him, but wouldn't share what the charge was.
Okay, and did you make arrangements for him to come home?
We did.
And what were those arrangements that you made for him?
Well, the original plan was to pick him up, my wife and I, to go out to dinner, and at the end of the hike is to pick him up and bring him home. So there was no vehicle. So this was a Thursday, if I remember right, because it was near the weekend. And at that point, it was getting near the end of the day, and we were like, how are we going to get a rent-a-car at the end of the day? And then at that point, I believe I called you to ascertain what exactly is the expectation in terms of his arrival back. He only can get home so quickly. And so it was nearing 5 o'clock, and it necessitated, based on a conversation with yourself, it necessitated him getting back as soon as possible. So I got involved to have to make a call out to the rental company to see if they would stay open a little bit longer because he was going to be on his way.
Okay, and what day did he come back?
July 9th.
The next day.
The next day, he was 9 o'clock a.m. He was at Barnegat Police Station. Drove through the night.
Okay, and do you know if he was arrested on that day?
He was.
And do you know what the charge was on that day?
I do.
And what was that?
Endangering.
Okay. Now, between July 8th of 2021 and March of 2022, did Christopher live at your home at any point?
Yes.
And during that time he lived at your home, did he work?
He did.
Okay. Did he also have a girlfriend?
He did.
And what was his girlfriend's name, if you know?
Laura.
Okay. And between July of 2021 and March of 2022, would he live between you and his girlfriend's house?
Yes.
Now, did there come a time in March of 2022 that you understood that Christopher was arrested again?
Yes.
Okay. And how did you find that out?
Actually, my daughter told me.
Okay. Your daughter, Kim?
Kimberly.
Okay. And do you know what he was arrested for at that point?
I do.
Okay. And what was he arrested for at that point?
Murder.
And this was almost a year since Corey had passed?
Yes.
When between July, let me go here. After Corey passed, did you have any type of memorial for him?
We did.
And when was that?
I believe it was April 8th.
Okay. And can you tell us about that?
Well, we had a separate wake subsequent to the wake with his mother's family, and a separate ceremony at the cemetery.
Okay. Was Christopher present for the memorial?
Objection, Judge. I think I don't understand the relevancy.
It's overruled. You can say he was present for that.
Was he present?
Yes.
Thank you. Good morning, Mr. Gregor.
Morning.
Now, you testified before that your son, while he was in Baltimore, was in a program at Johns Hopkins, correct?
Correct.
And your son had previously graduated college from an online school, correct?
For his bachelor's, yes,
And he had been to several different undergraduate schools, correct?
he did.
And he ultimately finished his education with an online program, correct?
I
His
believe
undergraduate.
I believe he received his associates from the county college and then the bachelor's from
Right.
Ashford.
So you testified about a time period where you were caring for Corey, correct?
Yes,
And during that time period, you would be the person who would go through Corey's book bag, correct?
I'd be one of the people that went through his book bag,
And you would be the person who would get him off of the bus, correct?
generally.
And you would be the person who would be checking his schoolwork, correct?
One of the people.
Okay. And you testified at a previous hearing, correct?
I did.
And in that previous hearing, although you're testifying now that you were responsible for all of these things, you couldn't recall what school grade Corey was in, correct?
At that time, that's correct.
And if you were the person doing all of these things, then your son wasn't doing those things in terms of being so involved in Corey's education, correct?
No, it's not correct.
So your son was more involved in Corey's education than you were?
I really didn't assign a percentage of who was more responsible. I took it as when I dealt with his schoolwork that I was 100% responsible in understanding where he was in his classes, what his assignments were, what he was struggling with, and what he was doing well with. That information was passed to my son as soon as he got home and in very many discussions so that he could pick it up and go through the same work that I did and understand all the things I just mentioned.
Okay, but you were actually the person physically going through his book bag then, correct?
I was one of the people.
Right, and you were also the person you testified before who got him off the school bus, correct?
Generally, I did, yes.
Okay. So, based upon what you said then, you would agree that you were pretty integral in terms of caring for Corey while he lived in your house, correct?
Absolutely.
And then during August, right, the defendant and his son moved away from your home, correct?
That's true.
And at that point in time, they actually moved to Barnegat, right?
They did.
And they moved to the Atlantic Heights complex in Barnegat, correct?
They did.
And when your son moved with your grandson, at that point in time, you would have been less involved in Corey's care and education, correct?
Yes,
And that would be because you weren't with him every day, correct?
that's correct.
And at that point in time, it would have been your son's responsibility on his own to care for Corey, correct?
Correct.
Because you weren't there every day anymore, correct?
No.
And he would be solely responsible for going into his backpack, correct?
Correct.
And he would be solely responsible for making sure that he got picked up from school, correct?
Correct.
And he no longer had your guidance and your assistance at that point because he was no longer living with you, correct?
Are you referring to Corey?
I'm referring to your son.
I would give him all the verbal assistance I could every time we talked on the phone in terms of how he was doing and what the plan was to help him.
Right, but you were no longer physically there to actually assist in this, correct?
That's correct.
Okay. So I'm going to take you to March 22nd, I believe is the date that you testified about. And on that day, you and your wife went down to Barnegat, correct?
We did.
And you saw your son that day, correct?
Correct.
And you saw Corey that day, correct?
We did.
And you spent a few hours with your son and you spent a few hours with Corey, right?
Correct.
And your wife noticed that Corey had a bruise on his forehead, correct?
He did.
And did you see the bruise located on Corey's forehead?
I did.
And during the course of this case, on April 2nd of 2021, after Corey passed, you spoke to Detective Mitchell with the prosecutor's office, right?
I did.
And you gave him a pretty long statement, correct?
It was.
And when you were speaking to the detective, nowhere did you tell him that Corey had this bruise when you saw him on the 22nd, correct?
I don't believe I mentioned it.
And with all of your training that you just talked about and being a police officer and in Homeland Security, this wasn't important for you to mention when you were talking to the detective, correct?
I didn't think it was any more significant than him telling me he fell in the treadmill.
Okay. So Corey told you that he fell on the treadmill?
It was a joint discussion at dinner.
Okay. And again, this wasn't important to you at that time?
Well, it was important that he had a scrape on his forehead,
Okay.
but I didn't think to mention it to Detective Mitchell.
Okay. Now, calling your attention to April 2nd, you spoke to your son while you were driving down to the hospital in Stafford, correct?
Correct.
And when you spoke to your son while you were driving to the hospital, you told your son that you were going to contact the police, correct?
I did.
And that was based upon conversations that you had with your son on that day, correct?
It was.
And when you got to the hospital, after you had told your son that you were going to contact the police, your son wasn't there at the hospital, correct?
He wasn't in the emergency room now.
And when you got to the hospital, Corey was there by himself without any family member, correct?
That's correct. They wouldn't let my wife and I in.
Right. And your son, though, he was not with Corey when you got to the hospital, right?
No.
And in the time between from when your son left until you got there, Corey was alone in the hospital without any family members, correct?
As far as I know.
And when you got to the hospital and your son is not there, you were trying to find him, correct?
Correct?
And you were basically telling him to come back, correct?
When I did talk to him, I told him he needed to come back.
Right. And in fact, you didn't even talk to your son again until the following day, correct?
That's correct.
And that would have been on April 3rd, correct?
Yes.
And let's say the night of April 2nd, you didn't talk to your son, correct?
I didn't talk to him now.
And you didn't know where he was the night of April 2nd, correct?
I didn't know.
And then the morning of April 3rd, you didn't speak to your son, correct?
No.
And you didn't know where he was the morning of April 3rd, correct?
No.
And then finally, on April 3rd, your son calls you, correct?
Correct.
And when he called you, he was in Arkansas, correct?
That's what I believe, and I believe it from looking at the phone log. I don't remember him telling me he was in Arkansas.
But it's your understanding, based upon what you reviewed, that he was in Arkansas, correct?
That's what I believe.
Okay. And then you're the person who told your son to come back, correct?
We all did.
And you told him that he needed to get home from Arkansas, correct?
Correct.
Now, the next time you saw your son would have been on April 5th, correct?
Yes.
Okay. Now, that summer, your son and his now girlfriend, what's her name?
Laura.
Okay. So that summer, your son and Laura actually went on a hiking trip, correct?
They did.
And that would have been a few months after Corey passed?
3 months.
And the two of them went hiking in the Appalachian trails, correct?
They were in Pennsylvania. I think it was the Appalachian Trail.
And they also went on a van trip up in Maine. Isn't that correct?
I don't recall that.
But they spent time traveling together, correct?
That was, yes,
And that only would have been a few months after Corey's passing, correct?
August is 3 months after he passed, yes.
Thank you, Judge. No further questions.
Yes, Your Honor. Mr. Gregor, on cross-examination, Ms. Lento asked you if anybody was with Corey when you were on your way down to Southern Ocean Hospital, right?
Yes,
Okay. On your way from Monroe to Barnegat, were you aware that Corey had already passed?
yes.
Thank you.
No further questions, Judge.
All right, sir, thank you. You're excused. Councilman, I see the side button. Ladies and gentlemen, a couple of issues. I know you asked about the TV. So that's not being broadcast anywhere. So although the camera does shine on the bench in the jury box, the only thing it's used for at all is if we have the courtroom filled to capacity, we could have a second courtroom for spectators, but it's only relayed to that courtroom the same as anyone would see if they walked in. And there's no filming there permitted. If there is a second courtroom, sheriff's officer would be there making sure no one's using a phone or anything like that to take any photographs. So we've maintained our promise to you that you wouldn't be photographed or otherwise broadcast anywhere. Secondly, we continue to experience the same problems with witness scheduling. There's a whole series of factors that go into these things, and it just hasn't really fallen into place for us. I think what happened was we had some people who had commitments that had to testify early, and then some people who had commitments that prevents them being here when we needed them. So the trial's been much more spread out. But again, that shouldn't affect anything you do or any way you consider anything. So for today, though, that's the only witness we have. I've spoken to the attorneys, and they tell me that there's potentially a few witnesses for tomorrow. Probably won't be the full day, and I know we didn't quite get started today, so I would say, could you report at 10 o'clock tomorrow? This way you're not rushing here in the morning. And then Friday, of course, we won't have any testimony, and then we'll give you an update tomorrow what's planned for next week, but we still do have a couple of days planned for next week. We're still on track to finish the trial before the outside date I gave you originally during jury selection. So I thank you for all that cooperation and appreciate it. It's unusual, so on behalf of the court, I apologize for it, but things like this come up, and it's my job to try and handle it and move everything along, which I'm trying to do the best I can. I also don't want you to have too long a break when you're without being here, because I want to be able to check in with you, make sure you've indicated you have no outside influence or concerns or anything like that. So I know it's a short day, but I appreciate all your cooperation. So we'll excuse you for the day. Please take your belongings. Report to jury assembly tomorrow at 10. Again, don't discuss the case amongst yourselves. Don't do any research. Don't form any opinions. Don't let anyone speak to you. If you need any updated letters from jury assembly, I know I gave you a schedule, but jury management's been advised that if you need something specific for an employer, that you have these non-consecutive days at all to explain that. Let Karen Riley, the jury manager, know, or one of her staff, and they'll get you a particularized letter if the regular form letter is not sufficient for you. So again, please follow my instructions. Thank you for your cooperation. Anything from counsel?
No, Judge, thank you.
All right. Ladies and gentlemen, again, thanks so much.
It's always easier. Throw us off. Oh, thank you. Yes.
See you tomorrow.
Remember to take your phones.
Don't forget your telephones and your watches.
Yes.
Thank you, sir.
Thank you.
Wait for John. All good, John? Very good.
All right, it's 10:53. The jury's been excused for the day. There are additional issues we need to address outside the presence of the jury. Mr. Glucci, you want to take a brief recess before we do that? Or? Me too. All right. So we're going to have at least some type of hearing with respect to certain developments over the last couple of days and whether or not certain witnesses are going to be called or not called, but we'll give everyone our mid-morning break. We'll come back out and we'll discuss that outside the presence of the jury. Thank you.
All right,
Thank you, Judge.
please step out.
a.m. The jury's been excused for the day.
So Judge, after we broke, I met with Ms. Lento and Ms. Schroen, and we actually watched the portion of the video that I wanted to play. It's less than 3 minutes. It's from the 49:50 point until 53:20.
Right, but just for clarity of the record, what we're talking about is a police video generated from the stop of Mr. Gregor, Tennessee on April 4.
It's the Alcoa, Tennessee Police Department at the car stop in Alcoa, Tennessee. The portion of the video I wanted to play is where the officer who's talking to Mr. Gregor is explaining to him what's happening and what the possibilities are surrounding his car, including we can wait 2 weeks for Jersey to drive a search warrant down here, or you could just waive it, and he's saying, I'll waive it, you can search the car. Then he talks to him about the phone, that they're probably going to want to dump the phone, and he says, what's that? And they explain it to him, and he says, okay. It's his demeanor. You know, he's standing there, he's agreeing to everything they're doing. It goes directly to, I believe, you know, his consciousness of guilt. I mean, it goes directly to what he's talking about, his demeanor and how he's behaving. After, and I don't want to speak for them, but after they watched that bit, and when I say that, Ms. Schroen and Ms. Lento viewed the video, they wanted an opportunity to watch the whole video, which is about 2 hours. I'm more than happy to stay here and just do it here, sit in their office, or do it separately, whatever they want, whatever they prefer, to watch the video to see if there's anything else in that video that they want played. I'm hopeful that between 4 of us, 5 of us, we can come up with some sort of stipulation as to the playing of the video for the jury. Also, I spoke to Detective Mitchell, who gave us the information on, I believe it's Murphy?
Yes.
Patrolman Murphy in Seabright. Detective Mitchell has agreed that he will make his best effort to contact this person and have him here tomorrow at 8:30. Ms. Schroen just told me that the 2 Barnegat police officers that I've requested will be here tomorrow at 8:30 for me to talk with them. And Detective Mitchell is still here, waiting for me to meet with him and speak to him on whether he will testify or not. So depending on the stipulations, and depending on what your rulings are on the video, and if we can't agree, then we're going to have to make some decisions on that, and we can do that later. I'll be here all day if you want. I'll do whatever you ask me. And I'm sure that they will too. So that's where we're at as far as that's concerned. Now, do you want to?
So before we get to any of those issues, Mr. David Gregor came into courtroom. Since he's testified, any objection to that by either side?
No, Judge, but would that go for the same for our witnesses too? Because we've been telling them not to come to the courtroom, so.
So at this point, I doubt very much that I'm ever going to call Rebecca Micholo. Can you give me till the end of the day to make a decision?
Well, I just want to make sure that if he, you know, that we're telling our witnesses the correct thing too, because we've told everybody technically the trial is not over; they're still under sequestration. So,
right. The defendant always has the ability to recall the state's witness.
right.
David Gregor was the defense witness. I don't
Right.
think you're going to call him, so, and the defense has already called him, so. I'm just
Judge,
pointing out that he's here, and I want to make sure. But given these unique scheduling and evidentiary issues, I don't think I can put pressure on Mr. Gallucci to say right now he's not going to recall the state's witness. We did, in fact, talk about whether he would recall Detective Sergeant Coles at one point. So I think you're making the right decision by telling your witnesses at this point there's still a sequestration order in effect.
Thank you, Judge.
All right. So you want me to hear from the state as the issues you just brought up, then we'll talk about the other issues?
Sure.
All right, what's the state's position on? First of all, any problem with the 3 police officers tomorrow at this point, assuming they're okay?
No problem with the officers. The Detective Mitchell, Officer Dugan, Officer Roman will all be here at 8:30 in the morning tomorrow, subject to any conversation Mr. Gallucci has with them otherwise.
Good.
And then we're assisting with the Seabright issue as well. With regard to these body cameras, we would like a chance to go back and review the full camera, there are a number of cameras from different angles, from different portions of the interaction. And this particular one, Flock Video 2, that counsel pointed out, is 2 hours long. And it's a snippet. It's not the whole story. It's not everything that's happening. So Ms. Lento and I need to review it, decide what we want to agree to, if we want to ask that the whole thing maybe be played instead of just 3 minutes of it, or if we want to do it by way of a stipulation. But we need a chance to speak together and look at it in order to make that determination. We also have a transcript of it. We want to go back and look at the transcript as well, and then we'll confer with Mr. Gallucci, and maybe we can all agree on something. At this point, I don't have an answer to that.
All right, and you want to do that privately, you don't want to play the whole thing in court, you're saying, or are you saying that?
We want to speak at least privately.
Judge,
I'm saying, are you proposing that you want to play the 2 hours in court, or that the two of you
We
want
don't
to
need
do
to
it
do that
privately?
in court. No, we can go back to our office, and then we can either talk to Mr. Gallucci in person, on the phone, whatever we need to do.
So I perceive that the only real evidentiary issues are what's admissible from the video. Theoretically, one or both of you could compel a Tennessee police officer to come here to testify for just a few moments about what his position is, that he was there, and the video accurately depicts the events that are recorded that day.
Judge,
So
that's
the-
absolutely correct, and we made a decision
Right.
not to do
All right.
that.
So thank you
The
for
state
that.
made
So
the
the
decision.
authentication issue is really relatively simple. It's whether or not hearsay statements on the video are permitted to be played, and if so, what statements are permitted to be played. And if you needed some instruction that they're not for the truth of the matter, but they're to establish the defendant's demeanor or conduct or behavior on that date, I could obviously try to craft that instruction for you in that regard.
And Your Honor, I'm sorry, I think I misspoke. What I was saying was that the state made the decision that we were not going to try to call somebody from Alcoa in our case to try to proffer any portion of that video. That's what I meant.
Oh, okay.
I know.
All right.
I don't think it was responsive to the court.
No, actually, I didn't understand you then. I took your position to mean that you weren't going to dispute the authentication of the video.
That's part of what we want to talk about today.
All right.
Are you saying it wasn't?
We want to talk about
You wanna
all
talk
of
about
it
all those
today
issues
before
to
we
say if-
take a
if I
position on
agree
the
to that.
record. Yes.
All right, so we'll give you an opportunity to do that later. Now, the next issue is the decision to call or not call Carolyn Gregor, the defendant's mother. Who would like to begin with that issue?
Judge, I can begin. The state came into possession of a recording of a phone call between the defendant and his mother that took place, I believe, last Friday, subsequent to the testimony of Carolyn and David Gregor at the 104 hearing in this court. During the phone call, the state asserts that the defendant was coaching his mother with regard to her testimony. I sent it to the court. I sent it to Mr. Gallucci last night and indicated that if Ms. Gregor testified, or even in the defendant's testimony, basically anybody that makes that relevant before the court, I will, subject to any rulings from the court, be looking to use that on cross-examination in whatever form I need to at the time.
Thank you, Mr. Gallucci.
Your Honor, as you know, I'm in charge of making the decisions on who the witnesses are going to be that testify in court. And what Ms. Schroen just said is very accurate. I received not only a transcript of that recording, but also the recording itself. I don't necessarily disagree with Ms. Schroen's interpretation of that conversation, but that conversation does make me not want to call Mrs. Gregor as a witness in the trial. I will say that at every single moment she had the opportunity to stop her son from speaking about the case and trial strategy and whatever else he wanted to discuss, she made every attempt to stop him from talking about it, but he persisted. And at one point actually even hung up on her son because he continued to persist. At one point you actually hear his father in the background say, stop, and basically enough is enough. So as a result of this conversation, I find it necessary not to call Mrs. Gregor as a witness in this case. Mrs. Gregor was going to be a fact witness and basically testify, not even as long as Mr. David Gregor testified, but she would have testified basically to conversations she had with her son the morning that Corey had come home. So it was going to be a very limited examination anyway. So as a result of this conversation that my client was involved with, I will not be calling Mrs. Gregor.
All right, thank you both for that. Ms. Sharon emailed the court with a copy, obviously to Mr. Gallucci, containing a transcript of the recorded telephone call and indicated that she intended to seek permission to be able to use the same. And first thing this morning, Mr. Gallucci asked for the ability to conference the matter, which we discussed in chambers, but everything that's been discussed in chambers has been repeated out here in detail. The court agrees with what counsel have said. It's well settled law that any attempts by a defendant to influence, change, or alter the testimony of a witness, whether that be through threats or promises or entreaties or otherwise, can be admissible. In fact, it can be admissible on the issue of consciousness of guilt. I've already gone through a long analysis on the admissibility of post-offense evidence regarding consciousness of guilt, namely the defendant's alleged flight to Arkansas and Tennessee, his alleged deletion of internet history and text messages. So in that regard, I would have had to make a decision about not only the ability to cross-examine defense witnesses, such as Ms. Gregor, on what influence the defendant's conduct may have had on her, but whether or not that conduct also would be separately admissible by itself. Our Supreme Court has recognized that the relevance of post-offense conduct to a defendant's mental state is important, and courts should address it if it demonstrates a consciousness of guilt. And again, I'll cite State v. Williams, 190, New Jersey 114 at 125. That's a 2007 New Jersey Supreme Court case. That's a case I cited last week in regard to other post-offense conduct evidence. And in that Williams case, statements made by the defendant towards witnesses to get them to alter or change their testimony were deemed admissible as to the defendant's intent. So here, the defendant evidently was still foolish enough to try and engage in that conduct, even while the attorney was obviously meeting and preparing with witnesses. Both sides have correctly summarized the statement. The statement ends, the phone call ends with Mr. David Gregor intervening and saying the conversation's over. In fact, he even says that they've been meeting with Mr. Gallucci, which was appropriate, and there's no reason to continue the call. And then both parents repeatedly say that this is the end of the call. It's over. Stop. So Mr. Gallucci's then been put in a situation to have to make a decision how to address that. I'm a firm believer in allowing attorneys on both sides to formulate trial strategy. The attorneys have access to all of the discovery materials, unlike the court, and attorneys have to make strategic choices both in advance of trial and during trial. One of the things that I often cite to is that trials are not perfectly scripted or choreographed theatrical presentations. They're more of an extemporaneous production whose course is often unpredictable given human conduct. Attorneys will sometimes be confronted with inadmissible evidence coming to the attention of the jury, or attorneys will sometimes be confronted with witnesses not being predictable, particularly in criminal cases such as this one, because in criminal cases there's no pretrial depositions like there are in civil cases. Witnesses may say things on the stand different than their prior testimony, or they may also sometimes be subject to outside information which could influence their testimony, and both sides have to try and react to that, and this is an example of both sides doing that. Our Supreme Court discussed that a trial is not a perfectly scripted presentation in State versus Yaw, Y-O-U-G-H, 208 New Jersey, 385 and 397, the 2011 case. And the court then has to make certain determinations. Here, as an example of trial strategy, Mr. Gallucci has made a tactical decision not to have me make determinations about to what extent the telephone call would be admissible. Instead, he's made a strategic decision not to call Carolyn Gregor to the stand. Trial strategy is left to the discretion of competent trial counsel. State versus Caruzzi, C-O-R-U-Z-Z-I, 189 New Jersey, Super 273 at 321, a television case from 1983. Here, counsel have had an opportunity to review the transcript, and I understand counsel for both sides have also confirmed they've listened to the actual recording, which oftentimes contains inflections and tones of voices and is likely more powerful than the actual written transcript. So therefore, both sides have had an opportunity to conduct a review of the situation and are making informed strategic choices in the matter. And informed strategic choices are virtually unchallengeable on review. I would also note that it's well settled in our state, and in fact, not only has the New Jersey Supreme Court said this, the U.S. Supreme Court has said this, that a defense attorney's decision concerning which witnesses to call to the stand is an art, and a court's review of such a decision should be highly deferential. At State versus Arthur, 184 New Jersey, 307 and 321, a 2005 New Jersey Supreme Court case, quoting the U.S. Supreme Court in Strickland versus Washington, 466 U.S. at 689 and 693. So in that regard, having had the benefit of sitting through the whole trial, also the benefit of the 104 hearings, I find that Mr. Gallucci's made a strategic choice that has been considered after a review and investigation of the telephone call produced, as well as in listening to the particular call itself, not just the transcript of it, that he's balanced the alternatives. Frankly, Miss Carolyn Gregor's testimony was of limited relevance. I indicated I would allow some of that testimony in. The vast majority of the things I would have allowed her to testify would essentially be repetitive to what Mr. David Gregor testified to. Even the bruise on the forehead, Mr. Gregor admitted that he saw that as well. Things about the demeanor of the child that Miss Carolyn Gregor testified to at the 104 hearing were covered by David Gregor during his testimony before the jury. In addition, one of the things I ruled in regard to Carolyn Gregor's testimony is that she could testify that her impression of her son was distraught and upset after the child had passed. However, Mr. Gallucci was able to elicit that from Mr. Gregor today in the presence of the jury. So that likewise would have been redundant and cumulative. The defendant's father testified today that his son's demeanor was hysterical in a phone call after the child had passed, and that his son was inconsolable because defendant had, quote, just lost his son, close quote. So therefore, many of the things that the defense counsel intended to elicit from Carolyn Gregor were already elicited from David Gregor. Mr. Gallucci indicated with respect to any phone calls or text messages earlier in the day from defendant to his mother on April 2nd, 2021. I believe those are also available by Sergeant Coles' testimony in the forensic extraction of the phones. So although I'm not right now being called on specifically to review the actions of defense counsel, it was worth placing this on the record to note that Trials are dynamic things change, evidence develops, the state has an obligation to produce any additional evidence which comes to its attention. It does, and it did in this case, it did it promptly. It provided it by email to Mr. Gallucci yesterday. He confirmed that he saw it, and he's made a strategic decision after a investigation, which he's entitled to do, and under those circumstances, I find things like trial strategy and strategic decisions made after consideration of all the facts and circumstances and potential advantages or disadvantages, those strategic decisions are really unassailable. That's why being a lawyer is somewhat of an art. It's not an exact science. You have 10 excellent lawyers try a case 10 different ways, and every one of them could have been effective and zealous and conducted themselves appropriately. Just like the decision about when to stop questioning a witness, when is one question too many. Same thing is when is a witness unlikely to help you, but perhaps on balance actually hurt you if you call that witness. So under all those circumstances, I find that there's nothing to indicate to me that defense counsel's acted in anything other than an appropriate strategic manner to represent their client to the best of their ability. All right, so is there anything else we need to address today? Do you want to come back this afternoon to talk about this video, or do you want to, would that be at a separate date?
Judge, if I have no problem staying down here and meeting with these young ladies, because if we're going to do the video, I would prefer to do it tomorrow so we don't waste time.
Right.
If I could put on the Barnegat Police, put on Seabright, and then depending on the video, put on the video, then I mean the only thing left really for the defense is Dr. Michael Bodden and whether or not Mr. Gregor's going to testify. And maybe Sergeant Detective Coles, depending on what testimony's coming out here. And that would be very limited.
Right, those, except for the doctors, will be short testimony.
Right.
What do you say about coming back?
Judge, we could come back 2:30 because I know it's a few hours to review. So if that would work for everybody.
Fine with me.
Thank you, Judge.
All right.
I have a 12:30 conference with Dr. Bodden, and I'll find a place here. So thank you.
So then, we'll obviously have some downtime here, so then I'd like to have the charge conference on the final charge then, before Dr. Bodden's testimony, because I don't think that's going to change the jury charge at all. So I'll have my law clerk print out copies of the draft final charge we have, so you can start to look at it, and maybe tomorrow we can, if we have time, or Tuesday, we could do that in advance.
Whenever you want. I serve you your pleasure.
It just makes more sense to do it earlier than over Memorial Day weekend if we
No,
can
I
avoid it. So.
would prefer to do it earlier. I think we have a lot of work to do over Memorial Day.
All right, so there's nothing further for now, then I'll see you at 2:30.
Thank you, Your Honor.
never slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting
We
after
have
it.
some updates. Detective Mitchell from the prosecutor's office, who's on the witness list, is present in the courtroom. I spoke with Mr. Gallucci about this. He has no objection as long as it's okay with the court, with him staying in the room, because this will pertain to his testimony potentially tomorrow.
I think it would just be much easier for him to just hear what he can and can't do.
Is that okay with
If
the
he's
court?
called as a witness.
All right.
Yeah, I don't have a problem with it.
So with regard to the witnesses that counsel wanted to call, Detective Mitchell will stay in case Mr. Gallucci wants to speak with him. Officer Dugan from the Barnegat Police Department will be here at 8:30 in the morning. Officer Roman from the Barnegat Police Department will be here at 8:30 in the morning as well. I just wanted to bring to the court's attention, he is not on the witness list. But the state agreed that we would produce him, and we are. In addition to that, during the lunch break, we received from Ms. Ferrante a copy of a subpoena from Sergeant Cerulli from the Barnegat Police Department. She's on the witness list. The state did not subpoena her because we're not calling her. It's my understanding that she's retired and doesn't live in the state. So I have not made contact with her, and I do not know what that would entail as far as her being here. As far as the Seabright officers, none of them are on the witness list. I know that we provided contact information to Mr. Gallucci, and I know that attempts have been made to get in touch with a particular officer or detective, and I don't think that has been successful thus far.
And Ms. Ferrante is actually working on that as we speak now.
As far as these body camera videos, if Your Honor wants me to move on to that with the Alcoa Police Department, Ms. Lento and I met during the break. We met with our supervisors. We met with our appellate unit. The state is objecting to any portion of those videos being played for a number of reasons. First of all, there's no witness that can authenticate anything on the video. There's nobody from Alcoa. And second of all, the videos contain hearsay. They contain statements by the defendant, and they'd be played, I don't know who through who, but the state wouldn't have any opportunity to cross-examine what's happening, what the defendant's saying, what anybody's saying really in the video at all, because nobody present on that video will be here testifying before the court. If the court decides that it is appropriate to have that brief portion of the video that counsel wants played through somebody, the state would ask that all the videos be played under the court rule and the doctrine of completeness, and we would proffer those videos to the court outside the presence of the jury first, for Your Honor to hear them.
Mr. Gallucci.
Judge, even if we were to produce a witness for them to cross-examine, the only thing they would cross-examine that witness on would be authentication. The portion I want played is less than 3 minutes, I believe, is a portion where my client is discussing, he's cooperative. He's cooperative with the search of his vehicle. He's cooperative with turning over his cell phone. He's cooperative with every command that the police give him. He's conversing about what's going on. It goes to his state of mind and his demeanor at the time where they're alleging that he is fleeing because he's guilty. And when you look at the video, it doesn't appear that that's what's going on. It's a 3-minute portion. It's a 2-hour video, and I don't have an objection. I mean, I would want Your Honor to look at the full 2 hours if you're going to say, all right, in the matter of completeness, I'll play it because there's a lot of stuff on there where the Alcoa police officers are discussing things amongst themselves that have nothing to do with the case at hand, but what they would like, what their understanding and belief of the circumstances surrounding it are, including things that they're talking about with Ms. Mitchell, which I don't even know how they got that information. So, because if you watch the video, you don't hear my client say anything about, from what I saw, Ms. Mitchell prior to that, and they're discussing it. So that must have been information they got from somebody, presumably from here. So I have no issue with you if you want to watch 2 hours of it. I want 3 minutes of it.
There's 8 videos. There's 5 of them that are 2 hours long. Some of them have no sound, some just have video, but there are at least 4 videos that have audio and video, and they're each 2 hours long.
Well, they're presumably cumulative because you have multiple officers.
From all different perspectives, but you could hear certain microphones on some. They're walking around, they're talking to different people. Like, you can't just pick one video and think like everything's just not funneled into that. Just 2 things that counsel said that I wanted to respond to. Without a witness putting those videos in, it sounds like there's a lot of speculation. There's not, the things that are not captured on the video then are not going to be coming into court. The observations that the officer is making of the defendant is not going to be coming into court. And as far as the defendant's state of mind, I don't think that we could just rely on 3 minutes of video as reflection of his state of mind. What happens before that 3 minutes and what happens after is certainly probative as well. Before the 3 minutes where he agrees to a search of his car, they have a whole conversation with him about the search warrant for his car. And certainly that had to have weighed on his state of mind when he said, oh yeah, well, you have a search warrant so you can search me. I mean, there's a whole lot of conversation. There's a whole lot of things that he's saying and doing and observations the jury can make of his demeanor, the defendant's, in that video outside the scope of that 3 minutes. It would be misleading to show them just the 3 minutes. It would not give them a clear picture of what's happening. And it's also completely inadmissible in the way that counsel wants to use it.
I disagree with Ms. Schroen, but I will agree with the fact that if you want to play all 2 hours of video, I don't have an issue with that. There are portions of that video, though, Your Honor, that are completely irrelevant. There's minutes of him driving around, not doing anything. The officer, driving to when they pull him over. There's communication between him and his fellow officers about what they believe is going on, and conversations about Brianna Micholo. Those are things that, if you let the whole thing in, that probably should come out. Right. But if Ms. Schroen wants the court to see everything of my client, I have no problem with them from the moment they pull him out of that car until the moment they let him go. I have no problem with any of that. And the video that I want to play from the one officer, 2 hours, is the guy that's mainly with him. The other videos are people that are standing where this young officer's standing, and I'm standing over here, and he's recording the same thing. Or an officer standing where a nice stenographer is standing, and videotaping. They're all the same. They're all the same video. The reason I'm sorry, I didn't mean to interrupt. The reason I chose the one is because that's the guy that's actually interacting with Christopher at the time.
So in terms of the authentication, the state has produced in the discovery, listed on the witness list, multiple police officers from Alcoa, Tennessee. The state's discovery really represents to the defendant that these are body-worn camera videos made and preserved at the time of his motor vehicle stop in Tennessee. Under that, if I'm correct that that's what's done, Mr. Galucci calls all defense investigators, says, we got these in discovery from the state, represented to us that these were the body-worn camera videos from Alcoa, Tennessee. I mean, because the standard for authentication is relatively low. Evidence Rule 901 does the document or video or electronic record, is it what it purports to be? So there's really going to be no dispute that that's what the jury's already heard testimony that defendant was there. Sergeant Coles tracks him there with 60,000 data points. Detective Sergeant Scuddy responds there to search the car. So the jury already knows all that. So in terms of whether or not we delay this trial again for Mr. Galucci to try and get an order or subpoena to fly in an officer from Tennessee to say, yes, that video accurately depicts that, I really think is unnecessary. The next question is, what part of the video is admissible? So I really don't want to play 2 hours of video for the jury, particularly if it's full of a bunch of hearsay conversations between police officers back and forth, not involving the defendant. What I envisioned was something in the inception of the stop or the couple minutes thereafter. I made rulings that the state was allowed to submit post-offense conduct as evidence of consciousness of guilt. Flight, not merely to another town or another county or a contiguous state, but flight several states away, hundreds of miles away, the deletion of text messages, the internet history searching for things, and I believe the subsequent deletion of that internet history. So once I've allowed that, the defendant's allowed to then submit some evidence to rebut that. That's the definition of relevance. Does the particular fact tend to prove or disprove some matter which is material to the case? The issue of his flight is material to the case. So at this point, I feel constrained because I've allowed the state to admit evidence to allow the defendant to at least provide some explanation for that. The jury could think there was a high-speed chase in Tennessee with multiple police officers trying to pull him over. So if the video shows him receive a signal by a police officer, emergency lights or a siren or whatever to pull over, and he pulls over without fleeing, and there's some polite cooperative exchange, for instance, the defendant saying his name, I don't think that's hearsay information. The jury knows his name already. If they ask him for his credentials, he produces a license. Those are not really statements for the truth of the matter. If he's making statements about what a terrible mother the child's mother is or something like that, then those should be out. But I don't see how, and I guess I need to watch this when we watch it, but that's what I was envisioning, that there would be some brief, typical conversation. And I have your driver's license, registration, insurance card. The reason I'm stopping you is because there's an alert out of New Jersey for you. Something like that. All things that this jury knows already. So what's the harm in some of that's hearsay? Of course, a Tennessee police officer is going to say, I'm stopping you because of X. Not even supposed to really put into evidence the existence of a search warrant, because that can imply a judge made a finding that there was some evidence of guilt, probable cause to search. So I'm supposed to give a limiting instruction on a search warrant. So frankly, the fact that Mr. Gallucci is willing to do that is positive for the state, that there's a court-approved search warrant in advance for the defendant's car. Now, you're right. Whether if he agrees to the car to be searched, but there's already a warrant, then you'll be entitled to have that come in. But I don't know why this is so difficult. I mean, the alternative is, I guess I could say, I've improvidently granted the application to allow all this post-offense conduct to be in. So, ladies and gentlemen, you're to strike that he went to Tennessee because it turns out from the GPS coordinates he's coming back and he was polite and cooperative with the police. So now you're to disregard my instructions on flight as conscious of guilt. Where we delay the trial for Mr. Gallucci to fly up officers from Tennessee to say whatever. So,
Judge, the portion, and I think maybe we could have more of a conversation about this after Your Honor sees it, but the portion that counsel wants to play is like 45 minutes after the stop. There's a lot that's said.
All right, so that's not
what
I thought you were
and it's all statements and narrative from the defendant, and he cannot circumvent the state's ability to cross-examine his testimony, his story, by doing this, and that's what this is.
Stop.
Judge.
And he pulls over, he's cooperative, he identifies himself, he's not looking to flee.
Judge, I have no problem with the whole tape going in, from the inception of the stop right through. I was just trying to save court time by limiting it to the 4 minutes where he's out of the car and they're discussing how they're going to search it, what's going on, and he's cooperative. I have no issue with you playing all 2 hours of it, but for when the officers are communicating with each other about what they believe is happening. Without it, they're talking about Brianna, they're talking about their suspicions.
Those things can't.
Right. But I have no problem from moment one where you see the officer driving his car, pulling him over, going to the window, identify. I have no problem with any of it.
But Judge,
I'm sorry.
We're back to the problem with the bits and pieces of the defendant getting his testimony before the jury in its entirety, and we don't get to cross-examine, and that is not how it works. If he wants to put his story before the jury, he has the option to get on the witness stand, to testify, and be cross-examined by the state. But this is not a vehicle, these body cameras, to get that story before the jury, to get his impression, whatever he wants, to let them make credibility determinations about him. This is not just a stop.
I was envisioning something where it was him identifying himself, not resisting, not fleeing. I didn't think it was all these statements about what Ms. Strong is saying. So
I don't see any of the statements that Ms. Strong is talking about.
He's talking to the police about what happened to Corey in his statements. And if counsel wants to bring in this little tidbit, I mean, the whole thing is relevant, but none of it should come in. There's nothing in our court rules that permits these statements in these body cameras that are 2 hours long from this defendant to come before the jury without cross-examination, or cross-examination about the officers that he was with that got to observe him and his demeanor when the camera wasn't focused on him, when he's sitting there in Wendy's chowing down, laughing, telling jokes.
Who is?
The defendant, 48 hours after his son dies.
Well, I can't make any determination unless I see something, but I'm not, how do I allow in 2 hours of it? You know, you're saying you have no problem with that, but how do I allow that in?
Well, I don't think you can allow 2 hours.
I mean, even assuming the two of you agreed to something like that, it's still my responsibility to make sure that we comply with the rules of evidence. We just can't have tons of inadmissible evidence presented to the jury. I was thinking that we were not dealing with substantive statements about the child or the happenings. I think we were dealing with things that the jury already knew. They was pulled over in Tennessee, and this was just designed to rebut the claim that he was fleeing, that he was cooperative. Theoretically, you could argue, well, if he was fleeing, why would he be cooperative? Why would he be pulled over? Why would he have identified himself? That's what I thought you were doing, not looking to get statements.
I wasn't trying to get in statements. I'm not. I'm trying to get in exactly what you just said.
Well, can you silence that then? Can you mute that?
I think you could do a lot of things to it. But their argument, and I'm not arguing for them, is that you need the whole thing. And I'm arguing that you don't need the whole thing. You just need the portion that goes directly to consciousness of guilt. That's it.
Well, I think you only said once that you need the whole thing, but most of the time you've objected to all the statements on the entire video. So.
Yes, Judge, that's correct. And it's not just one video. It's things happening from different angles that show important things, one from the passenger side, one from the driver's side, but also the different microphones. The video that Mr. Gallucci has the couple minutes that are important to him isn't even the best video. There's video of the defendant talking, giving this whole narrative in the video that's crystal clear in another one. So it's not just 2 hours, it's, 8 hours of videos? Maybe there's some overlap, maybe, but at least 2 hours we're talking about across 4 different videos.
To the extent one video has a better vantage point than another, it's really playing the entire second video in its entirety too. So, what do you want to do right now, outside the presence of the jury? You want to play the 3 minutes and only look at that, always?
We could do that, and we could play, if you wanted to, we could start with where Sean wants. We could play it from the beginning to the 53rd minute, if you want to do 53 minutes of it, or we can play the 3 minutes I want. I'll do whatever you ask me.
What's the state say?
In fairness to the court, I think for the court to be able to make a ruling on what this is, Your Honor has to know what this is that we're even talking about. We're making representations to you, but Your Honor has, if you're going to be making a ruling about it, should see what we're talking about.
That's why we're here. So I'm fine with that. Somebody, we get the TV in the correct setting?
I'll move it. I just want to speak to Detective Mitchell real quick about the different sound.
I'm not hooked up to the system.
Oh, I can play it, Mary.
From the beginning of that video.
Yeah, I mean. Let's figure that out. Judge, I have them all transcribed. I'm trying to figure out which transcript though corresponds to this particular video that council picked a portion of. All right, so flock video. No. I have that in the folder. No, these are secret. These are secret. This is one of these two. I don't know which one it is. Probably this one.
I think it's that one.
Your Honor, would you like the transcript?
Sure. Can we identify what this is on the TV now? What exhibit we're playing? Is there an exhibit number to it, or?
Yes, Your Honor. This can be S165. And this is the Flock 2 body-worn camera from Alcoa, Tennessee, and I'll mark the transcript. So the video is 165A. I'll mark the transcript as S165B. The transcript is 60 pages.
What was the word you said? Block 2?
Flock, F-L-O-C-K.
Thank you.
That's how they have it termed. Flock 2 video.
Thank you.
It's from 4/4/21. And I'm giving the sheriff's officer S165B, which is the transcript of the video, hopefully the transcript of that video. And Your Honor, if you find that that one does not track the video, I believe that it does. I have another one because they're so closely related. From the beginning, I can't tell. Can I proceed, Judge?
Yes, please.
Can I fast forward through the officer driving, Your Honor?
Right, I would think we'd probably
Quick.
start from when it stops.
It's in Boathouse. Yes, that's why I get a little frisky when you do that. When I see water, I just keep that, go ahead and get that handle. I ain't on your line. You see what I'm saying? When I see the wall and you reach it somewhere else, that's a totally different thing, right? You ain't got no guns, knives, hand grenades, that crazy. You been arrested for anything? Okay, any reason why you didn't have to do the fight for anything? That you can't material in there?
Maybe it's me, but I'm trying to follow along this transcript, and I'm not hearing, the words I'm hearing aren't on the transcript I have. This whole thing about the reaching for something, reaching for a wallet, and those things, none of that's in the transcript that I see.
Okay, Judge, thank you for telling me. That's why I had asked. Prior to coming here today, I didn't know, to be candid with the court, I didn't know we were doing this with the transcripts and the videos.
No, I
So
understand.
on the break, I'm trying to sort that
I'm
out.
not being critical of you. You did mention that.
Right. I don't think that this one that I have in my hand is the one that corresponds to this video either. I have the two that correspond to the videos where you can hear more that I brought. So we just might not have a transcript for this. Unless anybody else has one. you on the spot. I have all my transcripts here. Connect for a second so I can look at my own computer.
Sure.
Thank you.
Just showing your emails are up on the screen.
Thank you, Judge. You want to email
It's
it
77 pages long. If there was a place to, how would I?
to Emily?
Is that the,
Let's find out where.
May I approach? Or did you give the transcript back, Judge?
I have it right here.
May I approach?
65 pages, sure.
Thank you. Can I see what you have? Can I just see the beginning
Sure.
of what you have? You're reading this off of that, right? And I'd asked to renumber that as the 165B, disregard the one that we submitted to the court. Emily, I sent you a copy. Eventually, but I know it's gonna take a while. We have a, okay. Did it come through, Emma? Okay.
I'll print Judge a copy.
Thank you. Judge, may I continue playing it?
Do you want me to print for you, Judge?
I can read off the screen.
Okay.
Okay.
I can play, Judge?
Yes, please.
Thank you.
Is that crazy? Somewhere else, that's a totally different thing, right? You ain't got no guns, knives, hand grenades, that crazy? You been arrested for anything? Okay, any reason why they had his vehicle flagged for anything? That's Kim from Gerald in there. Picture of today. 2 minutes ago? Yeah, no. I was turned off useless now. What's that? No weapons on your resume? No, sir. Everybody speaks for him. Nothing on public statement hurt me or anyway? No, sir. This area you were free from nothing legal? No, sir. Is this your vehicle? Yes, sir. I can sense you guys searching the vehicle. It's nothing. I really have nothing. That was on your bus over here. You're telling me some kind of story about yes. Yeah. So I saw you and Gary still don't want to run. He gets the sand. No. So I don't know how he wants to do. I'll follow it. So. See like the door's open or cracked. Then. And I don't know if we can't run. Yeah. I mean, he gave me a sense, so he seems pretty cooperative. He's like, I have no idea. This is all about it. Yeah, that's what kind of made it. Yeah. Well, he's shaking. He's like shaking on the steering wheel. Yeah.
Maryland. He's coming. He gave consent, but we're not.
Yeah, so stopped him for speeding in the construction zone. He's going 8 miles an hour at the speed limit. Are between corrals. She just got off with a complaint from New Jersey. Both of them have New Jersey IDs. Maryland bag. She doesn't know if this is his vehicle or not. She said the reason she flew from New Jersey is so that he didn't ride by himself back to New Jersey. And she's done it for about 2 years. She knows his first and last name, and they're kind. And she goes, I said, who is he? And she goes, friends.
He's giving a soft story about his kid dying and some other stuff.
Yeah, she's not said any of that.
So that's it.
I ain't got that part of it.
I know. Exactly. Be specific.
So I'm like, if it's a no thing, okay, but I don't want to be nonchalant. We walk up, we got a murder something.
Well, and I'd say like that.
Or kidnapping, or
Yeah.
something.
Well, I had a feeling when there.
Yeah, he definitely did not want us behind.
Oh, I know. That's what.
Yeah.
I mean, and he's shaking like a leaf, like his wallet's in his lap, and he starts reaching somewhere else, and Adam's like, whoa, what are you doing? Wallet's right in your lap. I see it. And he's like, he puts his hands on the steering wheel, he's doing this number. I'm like, you don't know, and of course you don't know what's going on. Why
See,
would
what's
you?
what the dog says.
There's plenty of dog hair in there. There's plenty of dog hair in there. That's like it's at least a 15, I would think.
I've never heard that hold for a search warrant. A search warrant's mean what?
Yeah, exactly. I mean, is he connected with a murder, or there's evidence in here that needs to be? Because he was mentioning something about his son dying and some other stuff, blah 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 blah. Some soft. Is he going to be investigated for child death? I mean, why would you be down here from New Jersey fixing it up? McGee House and Airport, all places. If she just flew from New Jersey, like, their story doesn't make sense. And when he came out, I was with Adam at that stop. Elsa's on. I'm like, I'm right here. And then I looked, they didn't give it out until like 2 minutes after the fact.
Well, I know that y'all has a split.
Yeah. Yeah, usually, because I saw him what they did at the gas station or whatever. I'm like, well, I ain't seen it, so he's going to the airport. He's about to get the split. Real out there on that guy with the gun and the moonshine business yesterday.
Got a Class 8 on the all day in the terror.
Yeah, real.
It was also and you got sponge. He is an outlet.
Yeah. If I was reading that, I'm like, first of all, I'm like, where is that?
That's out there.
Yeah. Well, I looked it up and I'm like, holy hell.
After that, along the county fell out.
Oh yeah, you got me dizzy. But then on the screen, they say I see like a pursuit on there, I'm like, what the? I see he said you won. Wow.
She said on the
We're just trying to figure that out. Yeah, that's his car, and he's from Derby too. I don't know if that makes sense. Yeah, supposedly. That's why we're trying to figure out what. Yeah, I understand. We got PC, yeah. That's what we could figure out. Hey, if you want to run, you use that.
Yeah, I know, sir. He'll be paying in jail, but he's suspect in kid murder.
Yeah, so that's how
She actually asked me yesterday if she could fly out. She's like, I'd like to be there with you on the drive back. I don't want to be alone. And I said, okay.
You've been dating her on and off again for 2 years and taking a second.
I mean,
Take you a second to figure out one thing.
I'm freaking out right now because there's like
I asked her.
Yeah.
Come on, bro. You graduated college.
I went to grad school too, and I was a math teacher. So you know I don't know that. I just like those that can't do teach. But I mean, it's been an interesting past 2 years to say the least.
When you say date, you mean just like hooking up with her?
Not really. She's met my son.
Actually date.
She's met my son multiple times. I did. I just, like I said, I drew a blank. It's more power.
I asked her why she's here, what she was saying.
That she wanted to be here with me for the drive home. And she also might or might not say, because one of her main reasons was she didn't feel comfortable with me driving another 13 hours after I've driven so much already. Because I haven't slept well, as you can imagine. It's just, I don't know. To be honest. I'm like numb at this point with everything going on, and this now I'm like a little freaked out because I don't know. My attorney didn't tell me everything's going on, so. Like I said,
Bad already. I'm talking to you.
and I mean, like I said, I think I said
We've
it to
had 2
you.
things that don't add up this when you're reaching into the side.
And that's usually where I keep my wallet, and I didn't realize that it wasn't here. And I played football, so I might have CTE shirts and then I played outside linebacker. D2 school, it's NAIA, which is kind of like D2. It's in Lakeland, Florida, at Southeastern University, which is like a really Christian school. But yeah, I mean.
Playing against the baseball.
Okay. But like I said, when I first got out of the car and you guys searched me, I have searched. I just made sure that that
Make sure you didn't have like a grenade stuck in your pants.
Exactly. But if that was you, I apologize because I have like tunnel vision. But I said, I don't mind if you guys search my Facebook at all. Like, there's nothing that I'm hiding. I'm really not, so I'm not worried.
We'll get to that very soon, man. So, we're just hanging tight and trying to figure everything out why we're doing all this, so.
Sure. I'd imagine that you guys would know if there was a warrant associated with that. I'm like,
State of New Jersey is ran by Democrats, so we don't really communicate very well.
you and me both. But I'm just, I don't know. Like, this is kind of got me a little freaked out, you know? Like, I was one to call Timmy's, but I got plans for lunch, and I don't have any there.
Mom's calling out.
Thought it was some kind of internal leak or something.
Head?
No.
Inside?
Yeah.
Chest?
Like stomach area. Like or something.
That's
I don't. He didn't have any bruising on him, and I knew when he got home he was tweaking, and I knew something was wrong with my gut, but I just thought she had home waiting from everything that he needed sleep, and I should have took him like he was doing. A lot of these things, like, you know, it's partially my fault in the sense that if they truly did something, it wouldn't, like, you would actually blame for the drug addict mother, but he'd still be alive if I never came back from Baltimore to fight with custody. And, like, that's been going through my head this whole drive. And it's just got me fucked up. They've been doing, they planted marijuana in my people before, and I got arrested for that in New Jersey. And I lost my teacher license. I don't. She's a special kind of dirtbag. I mean, you know,
they're being in
no, 100% not.
This is your car that you lease.
Yes.
From Maryland, you live in New Jersey.
When I was in Maryland teaching, I got my master's degree from Johns Hopkins in special education and mathematics.
You got this.
To say the least. Sorry, it's mainly for like medical, but for it's not 5 for education, but one reason. Yeah. Regret ever leaving.
Not right now, but once this is all, we get this all figured out. And, yeah.
No, I just wanted to call and get it down here. No, I just want to call my attorney and be like, you know, what's going on? No, believe it or not, a lot of people don't talk like that in New Jersey. So I'm from it's the Northern New Jersey people that they don't like. Oh, yeah, not a my. It's that's pretty fun. I forget it. It's like Arkansas or Texas. But I drove hard. I genuinely, my brother's in California, or if you want to go visit him. Bless you. I left at 5:30 Friday afternoon. I drove straight without any sleep. I couldn't sleep.
I'm going to need you to say you weren't in Texas. If you were in Texas, where in Texas do you think? Or Arkansas?
I don't know. I definitely was in Arkansas kind of thing. But
That's way out of way, right?
I was driving on, what was that, 40 or something? But
Where you guys go to Texas?
I don't know, sir. I've just been driving for it.
How do you get 30 here in Texas?
My initial
Mexico?
sense,
I'm trying to get the border from Texas.
no. I mean, if I was, I wouldn't be heading back to the direction of New Jersey.
Well, but hey, where was the conversation to pick her up at the airport here?
Last night.
At the airport in Knoxville?
Because the flight times lined up where she would get in at a specific time. I don't know, maybe it wasn't a flight morning. I didn't check the flights. I didn't question why. I just said okay. So.
That part don't make sense here.
I don't think it doesn't make sense, but that's fine. It's not that.
It's a little warm for us, but we got sleeves and stuff.
Yeah, I took mine off.
The sun's out at that, right?
I actually ripped them off on the drive over.
Yeah.
Yeah,
He's all down while driving. You wearing a seatbelt? Yeah, you did. Take off your seatbelt. I said, no, you did with a seatbelt.
Okay, why you didn't pull? Please don't tell her I forgot her last name.
I'm going to tell her.
You're in Boathouse.
Okay.
remember at a point it was like Texicana or something. Texicana? Maybe. It was like possible. I remember seeing that like around where I came, but I'm not sure.
You said you live 5 p.m. Friday. You drove for
20 hours?
20 hours. 4 p.m. Well, which is 1 p.m. Next day. Don't worry.
And then I got to Nashville yesterday at like 6 in the afternoon. Ate dinner, got a drink, and then I got the hotel room, talked to her, and then went to sleep.
So, even though we've got Nashville, it's an international airport, it's not from New Jersey, right?
Yeah.
On the direct flight, we can't hear where there's no direct flight.
I don't know why. She's the one who chose the flight. I didn't ask it. I just said okay, and let's pick her up.
You said you did that on me, so I'm going to make certain this. You got it off.
Well, I guess it's back east, so it's kind of in the way, or on the way. It's like,
Head
yeah.
You're saying, okay, so.
Yeah, I mean, on the GPS, it has the directions right now. I am not heading this way. Like, I'm heading straight back to Jersey. That was my intention.
Would your previous location would be able to tell you where we were at?
No, it doesn't.
I
Like,
don't have no GPS up there that said, hey, I was at this location.
I have GPS on it, but it's not like, unless I type it in specifically, it wouldn't have it. So.
Thank you for verifying.
He's off the phone, so he must have the final whatever out here. It's just, I'm sorry. I'm just curious as to what the hell's going on with this.
We'll find out together.
Awesome. Here's about the same.
I want you to know it.
You can put your butt on my bumper if you want. Yeah, go ahead. Yeah.
My legs don't feel great right now.
That's fine. You can sit on the floor if you want. Whatever makes you more comfortable.
Stand up. I don't want you to think I'm going anywhere. My dad was a state trooper in New Jersey. Very much respect for police officers.
Appreciate you.
Unlike most people in New Jersey, but
Part of the territory, I guess.
just curious why. I'm not saying it's your guys' fault as a department, but why it's taking so long to get clarification.
No idea, man.
I mean, it is Easter, I understand that. Did it say when it originated, the search warrant?
We don't get that information after the letter on the phone for it. Trying to figure that out. I guess on a Sunday it'd be pretty hard to get a hold of people. They're probably usually off on the weekends.
we pause this for a moment, please? I'm on about page 29 of this transcript, actually 28, I was going forward to 29. I don't even, I only got a third of the way done here. I mean, I can't let this evidence. First of all, there's all kinds of prejudicial things to the defendant. They're talking about another felony child abduction, which the jury might misunderstand to mean this one. You know, there's conversations about him having an attorney already. He admits he's trying to get to Texas at some point, then to, apparently it's not Texas, it's Texarkana, Arkansas. His brother lives in California, he wanted to go there. How is, I mean, it's way too much hearsay by these officers. They're having conversations about other things the whole time. Trying to do some research at the same time here. I don't know what authority you have to try and introduce the defendant's statement, but when a defendant's statements, when he doesn't testify or hasn't testified yet, if offered by the defendant, are generally excluded. State versus Boyer, 221 New Jersey Super 387. That's at pages 398, 99. That's a television case from 1987. That also cites some other cases. So, I mean, the very beginning, where he's first pulled over, frankly, it's difficult to hear anybody, but he gets out of the car and he says, "You can search my car." So, depending on the state's position, I guess maybe some very brief portion in the beginning where I give the jury instruction that's not for the truth of the matter, but it's up for them to determine if it provides any evidence of the defendant's state of mind. But I don't know how I get there. I mean, the rest of this is, it's totally irrelevant. It's, frankly, I think a lot of it's harmful to the defendant. Shaking like a leaf and all these other things that, you know.
Well, that's why I only asked for 49.52.
You wanted that one section where he says...
Well, we're not even there yet.
No, it was one section we did go over.
Well, he's talking about going to New Jersey and all of that, but...
Right, he says, I already turned around and was headed back to New Jersey, and the officer asked him about his GPS. He says, show that.
But I wasn't even offering any of that because I knew all of the stuff prior to the 49th minute was all of this.
Right. You know, if you want to forward to that 49 minutes, I mean, it's already a couple minutes off 4 o'clock, and there's no way, whether the parties even agreed to put the whole video in evidence, it's just filled with irrelevant.
Judge, I will forward it, and the state, just for the record, does object to the beginning being played as far as the initial stop, because what led up to the stop's not coming in. The witness isn't coming in to testify about that. The witness that sees him shaking like a leaf for some reason when he's getting stopped, whatever that may be, isn't going to be here live to talk about his demeanor, which he would be asked about on cross. And the defendant says he's been arrested before, right away, which would have to come out.
Right. A couple times. First, he says it initially, he's been arrested before, very beginning of the video, then later he says arrested for marijuana, and the officer says we only give tickets here, we don't arrest for it. In Tennessee, the video starts, the officer's in the patrol car, he's wearing the body-worn camera, and it's only showing the interior of the car, so it doesn't actually show any operation of the vehicle, doesn't show
The pull.
I mean, no, it doesn't show the car pulling over right away, you can't tell when he turned his lights on, so it's not really helpful for that. But I guess let's go to this one segment.
I might be a little early. Mary, if you just want to tell the judge your part.
It starts at like 49.50 and goes to like...
I started at 48:24.
I'm looking for it as required.
Based on circumstances that happen, and that makes sense. So they want to process this.
Judge, it's page 31.
If I can get evidence, process this vehicle for evidence, make sure there's nothing there, then I can get you on your way.
Are they not responding? Is that why?
New Jersey says. Alright. So,
And I'm trying to get on the interstate.
I don't think they're all this much.
I understand. And I'm not
understanding
so it's not.
that's not.
No, I understand that, sir. This situation currently. I understand that. And I have no problem with that, to have a tech process the vehicle. That's completely fine with me.
Here's what will happen. We'll get somebody to come out here. If for some reason instead of waiting on you, instead of waiting, I want to see if their jurisdiction puts you up in a hotel. Because that would be fair.
How long does it take for the vehicle to be processed?
So worst case scenario, best case scenario, get somebody out here to be on your way to that point. Alright? Worst case scenario is that's what we do. Process it for evidence. We drop the phones, which is typically how they do it. So every time they process the vehicle for evidence, they take your cell phone.
So that's what they get the data from it, essentially? Okay, yeah, I have no problem with that. Am I able to, like, reach out to my family at some point to just let them know?
I'm gonna make sure if you want, I don't want to embarrass you. If you want to call people,
Oh, yeah. Yeah, I want to let them know because although I did not want to be home for Easter because of what we had planned that we weren't going to do, I do just want to let my parents know as well. They're going to be concerned.
Alright, so I'll tell you.
And then I have a nicotine vape. I know they're super lame, but am I allowed to take that with me?
It's not THC thing.
No.
So I'll make sure that New Jersey's not interested in your nicotine. And I'll go that route. They'll probably have to make you sign a waiver. Because I don't want to make them drop search warrant for New Jersey nicotine. I'm not waiting for that. So I'll get you a signed waiver that says, yes, you may process my vehicle for evidence. And then you get your vehicle back and then you drive home. Or you don't have the rest.
I don't. Okay, that's good to know. Yeah, that was my concern, honestly, sir. Because I don't know what the hell's going on. Yeah.
The question is whether or not you have to stay or you have to like leave. Now, or we can try to figure it out today. I'll tell them what to do.
Judge, that would be it. That's where I would ask you to end it. 53:20. Well, it says 53:22, but it's probably 53:20. That's the only portion that I asked to be played, where he's being told he's not under arrest, that they need to search the car. He says, go ahead and search the car. They talk about the phone. That's really the only part that I asked be played for the jury. The whole beginning part, I recognized as hearsay and what have you in there. The state, they wanted to play the whole thing, which is, I understand that position. I understand that position, but my part, I think, goes right to his state of mind. I mean, if we're to infer Corey Mitchell's state of mind in a 33-second video that we don't even see him on, how are we not to use a video where we see him on to describe his state of mind on what's going on for consciousness of guilt? Standing there, I'm sorry, Jamie.
No, I thought you were done. I'm sorry.
He's standing there, he's compliant, he's talking to them, they're explaining to him what's going on, he's explaining to them that he, go ahead, search my car, do whatever you gotta do. They talk about a phone dump, he's like, okay, just to tell me what that is. So that's really the only portion of the video that I'm asking to be played. I understand their position, but that's all I'm asking for.
Judge, the state notes its continuing objection for everything I already said. This is absolutely nothing like the video that we played through Ms. Mitchell, a witness that was there of Corey to show proof of life at the time that she dropped him off. Consciousness, talking, etc. It has nothing to do with Corey's state of mind. So that's not a comparison. That's like apples and elephants that we're talking about here. With regard to this tidbit in the video, this is not what Rule 106 says. You can't cherry pick a statement that's good for you. It's self-serving. It has nothing to do with cooperation taken out of its context. There's a whole context to when those statements are made. They tell him they have a search warrant. There's all those police officers there. Yeah, he's cooperative. Does he really have a choice at that point? There's a search warrant. He knows about that. It's been said a whole number of times. And he says a whole lot of other things in this too. So for all of the reasons I said, it being hearsay, it being violative of every other rule I've cited, the state very strongly objects to that little portion being played for the jury to circumvent this defendant being cross-examined about whatever self-serving thing he wants to say.
Anything want to add, Mr. Blucci?
No.
All right, so first, the court has to be guided by the evidence rules. Out-of-court statements offered for the truth of the matter in court are hearsay. However, there's a variety of exceptions to the hearsay rule. Evidence Rule 803, subsection B1, deals with a statement made by a party and offered by its opponent. So typically, it is for instance, the state offering a statement made by the defendant, and there's special constitutional protections in a criminal case. But in any case, either party can be offering a statement made by their opponent. No evidence rule, to my knowledge, nor has anyone cited one, which allows a party to offer his own statement when he doesn't testify. And offering one's prior consistent statements are usually not permitted unless there's a challenge that the statement being offered at trial is recently fabricated or made up. So generally, if the defendant does not testify, his prior statements, if offered by him, are generally excluded in evidence. And that's the case I just cited, the Boyer case I cited, which also cites to a case called State versus Ryan, no relation, 157 New Jersey Super 112. At pages 126 and 127, that's in a television case from 1978. The doctrine of completeness is really not applicable here. We're talking about the doctrine of completeness. For instance, the state highlights a particular statement made by a defendant. Let's say the state was trying to use something at the hospital, at a motor vehicle stop, with a body worn camera. The defendant then states that in order for that statement to be considered by the jury in its full context, the statements preceding it or following it need to be admitted. Here we're talking about apparently a couple hours worth of the defendant's encounter with Alcoa police. None of them were here to testify. Obviously, it's difficult to subpoena a witness from out of state, but either side could have done that. The officers make a variety of disparaging remarks about New Jersey. They obviously have little information about what's going on or what they can do. Not even clear that there was an alert for the car based upon what they've said. Well, obviously, they stopped the car for a reason. The officer attributes the car being stopped to speeding in a construction zone, 8 miles an hour over. But then there's some discussion about a murder suspect. On balance, if this statement was offered by the state, if this video was offered by the state, assuming it was authenticated by the Alcoa officer, I'd be hard-pressed to allow it because it's full of prejudicial things to the defendant. He's already got an attorney. He's been driving straight through for 20 hours, leaving. May want to go as far as California. Thinks he might have been in Texas. Has been arrested before, although arrests aren't even relevant. Even a conviction wouldn't necessarily come into evidence, at least not at this point in the case. So there's way too much hearsay by the officers. There's conversations about other types of matters. And then we get to, I'm going to use the page numbers in the exhibit, pages 31 and 32. The Tennessee officer is talking about New Jersey maybe coming to get the vehicle, but it's going to take a long time. It's Easter. He talks about putting an evidence tag on the vehicle. Then we can get you underway. At line 1287, defendant asks, are they not responding? Is that why? The officer answers, "We're having a hard time. New Jersey sucks, all right?" And then there's some further discussion. A lot of it's unintelligible. You know, no one's asked for what's known as a driver hearing, but it's hard to understand a lot of what is said in this video. The officer then says, "We've already talked about this. I don't want you to be here all day." The defendant says, "I understand." The defendant then says, "The situation currently, I understand and I have no problem with that to have a tech process the vehicle. That's completely fine with me." He also then talks about waiting a long time, maybe their jurisdiction, presumably referring to New Jersey, put the defendant in a hotel room. The defendant asks how long it would take for the vehicle to be processed. The officer is talking about, depends how long it takes someone to get here. The officer then says, "We'll dump the phones," which is typically how they do it. The defendant asks, "What do you mean dump the phones?" The officer asks, "So every time they process a vehicle for evidence, they take your cell phone, and they dump it." And says, "I don't know what that means." Then asks, "They get the data from it essentially?" The officer's responses are unintelligible. There's some woman speaking in the background. He says, "Okay, yeah, I have no problem with that. And I'm able to, reach out to my family at some point and just let them know what's going on." So in terms of the defendant turning around and coming back from Arkansas into Tennessee, defense has other admissible means of being able to produce that in front of the jury. First, defendant's father's already testified to that. Secondly, Detective Coles may have been asked about it. If not, he can be called by Mr. Gallucci. At a 104 hearing, he presented to the court a PowerPoint which included a map with 60,000 data points which showed a U-turn essentially in Arkansas. Coles testified it was southwest Arkansas and the defendant was coming back through Tennessee, and geographically that seems correct. In terms about the point of dumping the phones, whether that's consent, and it's hard to even see about is the defendant consenting to all this. So this thing about the tag or a tech putting a tag on there, it's unclear to me that that even means a full search. The officer from Tennessee is saying, at line 1271, "So I can get an evidence tag, process the evidence, and make sure there's nothing there. Then you can go on your way." The defendant, "I have no problem," at line 1303, "I have no problem with that to have a tech process the vehicle." I'm not sure they're talking about the same thing. But regardless, I tried to, I guess I imagined this was simpler or clearer than it seemed, and that it would briefly show the defendant being pulled over and being cooperative. So while I've endeavored to allow it to be admissible in some fashion, because any evidence which could potentially be consistent with innocence, such as returning back, could be admissible, it still has to somehow satisfy our rules of evidence. It's a monumental amount of inadmissible prejudicial evidence, all hearsay, with perhaps some evidence that the defendant turned around and came back, which is otherwise presentable to the jury based upon Sergeant Cole's defendant's father, who's already testified, and perhaps any other legitimate way Mr. Gallucci can get it into evidence. But at this point, I have to be a gatekeeper for admissible evidence in front of the jury. I'm not even sure the jury can understand most of what's said. In the beginning, I thought the initial inception of the stop, not the initial, but the inception of the stop would be something that could be presented. If anyone reviews this record, the video shows the officer walking up to the car. The body cam we're looking at, a body cam of an officer behind him. You can't even see the defendant. You just see the police officer there with his hand on his gun, looking into the vehicle, which is not particularly positive for the defendant either, making comments about the defendant reaching around, some comment that the defendant's reaching to the side of the door for his wallet, but the officer's telling him his wallet's in his lap already. So that's certainly not helpful to the defendant. It looks like he's making furtive gestures or something like that. So my initial thinking that there could be some neutral presentation of just the defendant being cooperative and not being difficult with the officers or not attempting to flee or resist further is not something that comes out from the video. If there's further witnesses or further testimony that changes that, that's fine, but I can't have it played under these circumstances. But I think, as I indicated, that it's already been established that the defendant rented a car and came back. The defendant's father established he wasn't arrested in Tennessee. He wasn't even charged until July with the endangering. The state didn't challenge that, doesn't dispute that. Didn't cross-examine the father on that issue, about the accuracy of that issue. So, the jury's going to obviously know he came back. Mr. Gregor came back from Tennessee on or about 5th or 6th of April. So, under those circumstances, we've watched a substantial portion of this, but for those reasons, it can't be admitted to evidence, at least not under the current proposal without witnesses here. Mr. Gallucci, anything else you want to address today?
No, Your Honor.
All right. So we're going to report at 9 tomorrow. We'll have the jury come in at 10 and hopefully you'll have some witnesses.
I'll be here at 8:30. I think that Ms. Schroen already said that a lot of the witnesses will be here at 8:30, so this way I have an opportunity to speak to them. I'm also going to request now, if Detective Sergeant Coles is available, I'll get Ms. Ferrante tomorrow. So this way I can get all of my police witnesses, talk to them all in the morning, and then put on who I believe will be helpful.
All right. And the state has no problem with Mr. Gallucci trying to speak to the officers in advance of the testimony?
Judge, without an investigator, that's not something that would be a normal practice. I mean, I guess it's really up to the officer themselves if they want to testify. I'm sorry, if they want to speak to him or not, but, I mean,
Judge, I'm not
we plan on coming over in the morning as well, too.
Well, I mean, whether they answer questions or not, Mr. Gallucci can at least tell them I intend to ask you about A, B, and C.
Yes.
Because, for instance, some of the officers may have done a variety of things, and
Right.
so at least they have a topic that they know they're going to be questioned about. They have to respond to subpoenas, so.
Right, so counsel and I spoke, we're going to come over in the morning and we're going to speak to them about the possibility of what's going to be asked in terms of the frame of the testimony.
Right, and
I'm checking with Sergeant Coles now. Hopefully, before we get off the record, I'll have a response.
thank you. All right, so I've handed out, my law clerk's handed out to you a draft of the final jury charge. It's 26 pages. Also handed out to you a copy of the model jury charge for count 1, endangering the welfare of a child. That's going to require some discussion. The endangering statute, as you know, contains numerous definitions of abuse, neglect, or abandonment, many of which are vastly different depending on the circumstances. So I'll need some positions from each side about what portions you think belong in there and what portions are just so unrelated to the allegations of the case that they should be removed. And then, I guess tomorrow, give me an idea when you want to have that charge conference on the record. No part of the charge conference will ever be conducted off the record in this or any other case, but I did have the documents handed out to counsel today. And then the state submitted a verdict sheet, not a particularly complicated verdict sheet other than respect, there's some direction about the lesser included offenses for count 2. So at some point, Mr. Gallucci, just address on the record whether the verdict sheet is acceptable as submitted by the state or not. All right, anything else for today?
No, Judge, thank you.
Thank you, everyone. Appreciate it.
Thank you.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast. I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, I'll